Understanding legal and ethical issues. Learning objectives. After completing this chapter, we will be able to define confidentiality, liability, responsibility. Understand code of ethics and ethical principles. Examine sources and types of law, liability, and explore legal issues in nursing. Introduction. The complexities of today's healthcare system presents many ethical and legal issues for nurses. Advanced technology, patient autonomy and privacy, and end-of-life decisions are just a few of the factors posing ethical dilemmas. As the role of the professional nurse expands to include increased expertise, specialization, autonomy, and accountability, so does the number of legal issues involving nurses. Definitions. Confidentiality is the right to privacy of records. Individuals have the right to believe that information disclosed to health professionals is to be used strictly for the purpose of diagnosis and treatment. Confidentiality is grounded in two premises and 2015. Because individuals own their personal information, they may share personal information to the extent that they wish and with whom they wish. Accepting personal information comes with an obligation to maintain confidentiality, an obligation that is even greater for researchers and nurses. Definitions. Policies. Decisions that governs action and determine an organization's relationship activities and goals. Procedures. A step-by-step instructions for how to complete the task. Or an established and official way of doing something. Or a series of actions conducted in a certain order or manner. Accountability. An obligation and willingness to accept responsibility. Ethics, the branch of knowledge that deals with moral principles. Definitions, continued. Responsibility, an obligation to accomplish the task. Or the state or fact of being accountable or to blame for something. Liability is similar to accountability, the state of being legally responsible for something. Authority. Authority is the right to give commands, orders, and get the things done. Or authority can be defined as the power and right of a person to use and allocate the resources efficiently, to take decision and to give orders so as to achieve the organizational objectives. Accountability. The act of accepting ownership for results or the lack thereof. Definitions. Common law. The type of law derived from earlier decisions made by courts, also referred to as legal precedent. Administrative law. Public law made by administrative agencies that are granted authority to enact rules and regulations to carry out specific intentions of statutes. Constitutional law. The branch of public law which deals with constitution, their nature, formation, amendment, and interpretation. Criminal law. The body of laws that prohibit and punish acts that injure individual people, property, and the entire community. Law and ethics. Law, rules and regulations. Laws are rules of conduct, established and enforced by authority, that prohibit extremes in behavior so that one can live without fear for oneself and one's property. Ethics, moral principles. Ethics is a science that deals with principles of right and wrong, good or bad. It governs our relationship with others. Ethics are based on personal beliefs and values that guides decision-making. Code of Ethics for Nurses. The Code of Ethics for American Nurses Association, 2015, makes it explicate the profession's value and standards of conduct. Originally adopted in 1950s. Code of Ethics. Compassion, respect, human dignity, and worth. Primary commitment to patients. Promotion of health, safety, and patient rights. Responsible, accountable provision of cares. Professional growth and competence of the nurse. Promotion of safe, ethical health care, work environments. Advancement of the nursing profession. Collaboration with others. Maintain integrity of profession, include social justice. Ethical principles. Ethical decision-making. The principles most directly related to nursing are the principles of autonomy, beneficence, non-maleficence and distributive justice. Autonomy. It includes respect for individuals to make decisions for and about themselves, even if those are not congruent with others' goals. Beneficence and non-maleficence. Beneficence is the duty to help others by doing what is best for them. This belief also implies the principle of non-maleficence, or to do no harm. One has duty not only to do good but also not to inflict harm or to risk them to others. Distributive justice. Distributive justice is giving a person that which he or she deserves. It implies that benefits and burdens ought to be distributed equally and fairly, regardless of race, gender, religion, or socio-economic status. Allocation, macroallocation, and rationing, microallocation, of scarce resources continue to concern in healthcare today. Allocation is the decision society makes regarding how many of its resources will be devoted to a particular effort, for example, organ transplants. Rationing is a decision regarding who gets the service or supply and who does not, again using the example of organ transplant. Legal system. Source, a thing from which another thing has been originated, like page from wood or cotton. Wood and cotton are sources. Law comes from variety of sources. Understanding the sources of law and the various types of law helps determine their impact on nursing practice. Sources of law, from which law derives its validity. 3 branches of government: legislative, judicial and executive. They, in conjunction with the Constitution, form the basis of the judicial system. Constitution statement of the basic principles and laws of a nation or state. Constitution. The Constitution is the supreme law of the land. It defines the structure, power, and limits of the government and guarantees people certain fundamental rights as individual. Influences of the 3 branches of government are reflected in statutory law, common law, administrative law. Statutory law, regulated by law, is enacted by the legislative branch of government. This type of law is designed to declare, command, or prohibit something. Licensing laws of healthcare providers, including nurses, are examples of statutory laws. Common law. Common law is judge-made law. This type of law is derived from earlier decisions made by courts. It establishes a custom or tradition by which other similar cases are judged. The custom is referred to as legal precedents. Administrative law is made by administrative agencies. According to certain statutes, administrative agencies are granted authority to enact rules and regulations that will carry out specific intentions of statutes. Types of law. The 2 basic types of law are public law, private law, civil law. 1. Public law consists of constitutional law, administrative law, criminal law. 2. Private law is further classified into tort law, contract law, protecting law, reporting law. Most common law affecting nursing practice is tort law. Types of law continue. Tort law, a wrongful act that results in injury, loss, or damage. Tort law is divided into 2 categories. Unintentional, intentional. 1. Unintentional law consists of negligence, malpractice, professional negligence. A. Negligence. Negligence is defined as failure of an individual not to perform an act, omission, or to perform an act, commission, that a reasonable, prudent person would or would not perform in a similar set of circumstances. Types of law continue. B. Malpractice, professional negligence. It evolves from negligence law and premise that all individuals are responsible for the consequences of their actions or inactions. For malpractice to exist, 4 elements must be present: duty, breach of duty, causation, injury. 2. Intentional torts, assault including sexual assault, battery, false imprisonment, invasion of privacy, inappropriate disclosure of information, libel, slander, and defamation of character are examples of intentional torts. Liability accountability. The state of being responsible for something. To understand malpractice, one must understand the various types of liability. Personal liability. Vicarious liability. Corporate liability. 1. Personal liability. As individuals, nurses are responsible for their own actions or inactions. This is referred to as personal liability. 2. Vicarious liability. The law ascribes negligence to certain parties who may not be negligent themselves but whose negligence is assumed because of association with the negligent person. 3. Corporate liability. Corporate liability holds that the organization responsible for its own wrongful conduct. Corporate liability includes the following: the duty to hire, supervise, and maintain qualified, competent and adequate staff. The duty to provide, inspect, repair, and maintain reasonably adequate equipment. The duty to maintain safety in the physical environment. Legal issues in nursing. Legal issues in nursing involve licensure, patients' rights, management issues and employment issues. 1. Nursing licensure is a credential provided by state statutes that authorizes qualified individuals to perform designated skills and services. In nursing, these statutes are referred to as Nurses Practice Act. 2. Uniform licensure requirement. One remedy proposed by the National Council of State Board of Nursing (NCSBN) is to develop uniform licensure requirement among the state that would not only facilitate nurse mobility, but also ensure public access to qualified practitioners. Multi-state licensure requirement is process similar to obtaining a driver's license, allowing practice in more than one state. The state of residence is considered the home state. All other states in the contract are remote states. Model Nurse Practice Act. It defines nursing, its scope of practice, titles, advanced practice nursing standards, educational requirements, and violations and penalties. 2. Patient care rights. These includes the right to privacy, confidentiality, informed consent, right to refuse treatment, freedom from restraint. 1. Privacy rights is the violation of person's right to be left alone without being subjected to unwarranted and uninvited publicity and to make personal choices without interference. 2. Confidentiality is the right to privacy of records. Individuals have right to believe that information disclosed to health professionals is to be used strictly for the purpose of diagnosis and treatment. Patient care rights continued. Informed consent. 3 basic principles of informed consent are capacity, voluntariness, information. 1. Capacity. Capacity to give consent is determined by age and competence, and legal age for adult status varies from state to state. Voluntariness. Individuals should exercise freedom of choice without force, fraud, deceit, duress, or any other form of coercion. Information includes followings: explanation of treatment and outcomes, anticipated risks, discomfort and potential benefits, answer to patient's questions, possible alternatives, may withdraw consent anytime. Patient care rights, continued. Right to refuse treatment. The right of competent adult to refuse treatment is guaranteed by Constitution. Legal documents adhere to these laws are advance directives, a living will, a durable power of attorney, freedom from restraints. Types of restraints. Physical restraints include straps, vests, mitts, seat belts and side rails with high padded walls. Chemical restraints includes drugs often used are benzodiazepine, antipsychotics, and dissociative anesthesics such as ketamine. Management issues. Management includes delegation and supervision, staffing the area of responsibility, reassessing staff as needed, following the organization's policies and procedure, and maintaining patient privacy. 1. Delegation and supervision. Nurses are personally liable for the reasonable exercise of the delegation and supervision activities. If a nurse makes an assignment to an individual who the nurse knows is not competent to perform that assignment, the nurse will be liable if the patient is injured. 2. Staffing. Adequate staffing includes not only the number of staff but also their skills level. For example, RN, LPN, OP, their experience, and the unit to which they will be assigned, for example, critical care. Management issues, continued. 3. Job reassignment. Floating it is the process of pulling nurses from one area of hospital to another. Floating nurses to unfamiliar areas, especially specialty areas, increase the chance of error and may increase nurses' anxiety. 4. Policies and procedures. They should be well delineated, clearly stated, and based on current and actual practice. Perform functions under specific circumstances. Requirements must be followed, such as education, training, and experience. Evaluation of competence. Policies and procedures continue. Release of information. The same guiding principles regarding release of information about patients also apply to release of information about employees is considered confidential and must not be released outside the organization. Incompetent practice. It is important for nurses to be familiar with both the organization procedures for addressing safety and professional conduct and the State Board of Guidelines. Employment issues. Nurses who serve in management roles are also employees, so they need to be familiar with growing body of discrimination laws for themselves as well those they supervise. Civil Rights Act. Title VII of the 1964 Civil Rights Act, CRA, bars discrimination on the basis of race, color, sex, or national origin, 1991. The Title VII governs all public and private agencies with 15 or more employees and addresses all aspects of employment, for example, hiring, promotion, discipline, supervision, performance, appraisal, dismissal. The two exceptions to the law are the bona fide occupational qualification, BFOQ, and seniority or merit system. Employment issues continued. Sexual harassment. In 1991, the Civil Rights Act was amended to expand the definition of sexual harassment in the workplace. Employees must establish proactive policies to sensitize employees to the problem and prevent its occurrence. Age Discrimination in Employment Act. The Age Discrimination Employment Act (ADIA) in 1967 made it unlawful for employers to discriminate against older men and women in decision regarding all phases of employment. Discrimination against individuals over the age of 40 and mandatory retirement for a person at any age. Employment issues continued. Americans with Disabilities Act. Title I of the Americans with Disabilities Act data of 1990 defines disability as follows. A physical or mental impairment that substantially limits one or more major life activities. A record of such impairment. Being regarded as having such impairment. Family and Medical Leave Act. The Family and Medical Leave Act, FMLA, of 1993 provide eligible employees with a leave up to 12 weeks during any 12-month period for the employee's own serious illness, the or adoption of a child, or the care of seriously ill child, spouse, or child. Employment issues continued. Occupational Safety and Health Act. In 1991 the OSHA published regulations designed to reduce infection from blood-borne pathogens. The Ebola outbreak in 2014, the usual protective gear and procedures were not always adequate to protect health workers. Also new virus emerged, for example, severe acute respiratory syndrome (SARS), in the early 2000s. Middle East Respiratory Syndrome MERS. The healthcare organizations will continue to be challenged to protect both their patients and employees. References: Effective Leadership and Management in Nursing 10th edition, Sullivan Decker, PG No. 94-108, published by Pearson, 330 Hudson Street, New York, New York 10013. Understanding Nursing Research 7th edition, Nancy K. Groove, PG No. 100. Psychiatric Mental Health Nursing 7th edition, Sheila L. Weidbach, PG No. 160, Wolters Kluwer, Philadelphia. Baltimore. New York. London. http://www.google.com